Special counsel Jack Smith subpoenaed Ivanka Trump and Jared Kushner as his criminal investigation into Donald Trump's 2020 criminal election interference heats up. And the criminal investigation is heating up indeed. Jack Smith is not hesitating and just filed a motion to compel the testimony of former Vice President Mike Pence following Donald Trump's baseless assertion of executive privilege and Pence's assertion of speech and debate clause immunity. Then let's turn to Arizona, where it was revealed this week by the new Democratic Attorney General, Chris Mays, that her predecessor, Republican Attorney General Mark Brnovich, that he concealed a report that his office prepared after 10,000 hours of investigatory work, showing that there was absolutely no evidence of election fraud in Arizona. This while Brnovich was out there on the Steve Bannon show and others spreading conspiracy theories about the 2020 election for Donald Trump. Look, I think Brnovich needs to be disbarred. We'll talk about it on this episode. Meanwhile, a federal judge in Washington, D.C. ordered Donald Trump to sit for a deposition in the Peter Strzok wrongful termination lawsuit in federal court in Washington, D.C. And this is a wrongful termination lawsuit that was filed against the FBI. Let's talk about those implications. And what is going on in Fulton County? Earlier this week, the foreperson of the special grand jury, Emily Kors, gave an unexpected and let's just call it questionable media tour, although later in the week, the presiding judge, Robert McBurney, said there was no problem with it. Let's discuss the implications of this and just generally what's going on in Fulton County, where things looked very organized. Things looked very much on the tracks where they were supposed to be headed. And there does look to be some disorganization there. And you compare that to the frankly, organization of special counsel Jack Smith's work. So let's talk about that all. But Michael Popok, how are you doing today?
I'm doing great. I'm on the road again. As people on Wednesday, I was in Atlanta, not because of the special purpose grand juror going on network television, because I was there. And now I'm in Miami, although you can't tell from the curtain behind me. Listen, I love all of our segments today, like children, like I don't have any favorites, but what the actual F is going on in Fulton County, we'll get there.
We will get there indeed. For all of our audio listeners only, Popok is rocking those original controversial glasses that really split the LegalAF community. But he's been doing some variations. We're back to those original large black glasses, and we'll talk about that too maybe later in the show. But let's get right into the legal news. Special counsel Jack Smith's subpoena of Ivanka Trump and Jared Kushner, of course, both testified before the January 6th committee. Look, Ivanka Trump was there during the insurrection. She was there in the White House when Donald Trump was making phone calls to former Vice President Pence and threatening him and saying, don't count the votes, don't count the electoral votes, throw it to the state legislatures. And Pence refused to do that, begrudgingly refused to do that, because I think Pence, if he could try to figure out a way to break the law, would have tried to do that. And we see what a spineless coward he is right now. And Ivanka was also at the Ellipse. We see her in the video there while the Trump family was literally dancing as our democracy was being threatened, and as a free and fair election was trying to be contested through a violent coup. And Jared Kushner flew back from the Middle East, where he was cutting personal deals for himself, likely including the $2 billion he received from the Saudi Sovereign Wealth Fund after Donald Trump left office, even though Kushner doesn't manage money. He's now a money manager and got a $2 billion check from the Saudi Sovereign Wealth Fund. Look, they both testified before the January 6th committee. So one of the questions is there going to be new information that special counsel Jack Smith is focused on here? And I think the answer is yes. And I'll give you my take, and then I want to hear yours, Popok. I think that special counsel Jack Smith is far more interested as well in the financial crimes that Donald Trump committed, in addition to the actual violent insurrection, in addition to the fake elector scheme, in addition to the threats that Donald Trump had made to state and local election officials. And so we know, for example, that one of the focuses of Special Counsel Jack Smith's investigation is on potential money laundering and campaign finance violations. And Donald Trump potentially creating, it looks like he did create these LLCs that he had individuals in his inner circle control, where money would be routed to that LLC so that Donald Trump's committees, whether it's his political action groups or other campaign committees, would just report. We now know the number to be close to $800 million that was just being sent to this LLCs, but you wouldn't know who the end recipients were. So I think Special Counsel Jack Smith's going to be focused far more on the financial crimes here. And also, let's not forget, there's not only a criminal grand jury about election interference, there is a criminal grand jury as well about Donald Trump's theft of government records, thousands of government records, including sensitive compartmented information. And while at first blush they may seem to be unrelated, I think they're inextricably intertwined, because one of the reasons Donald Trump wanted to and needed to stay in power, such that he needed a violent coup, was he was doing the bidding of foreign powers. And when he left, I think it was his intent to continue to do the bidding of foreign powers and our enemies. And we know Special Counsel Jack Smith has been asking lots of witnesses about Donald Trump's relationships with foreign governments and foreign leaders. And could he have been using these documents? I think he was, very transactionally, in order to exchange favors and get money from these various foreign entities. And as we know, for example, the Saudis having golf tournaments at Trump golf courses, while Donald Trump spreads conspiracies about September 11th. I mean, how heinous and despicable can you be there? And really, these foreign interests, our foreign enemies, are Donald Trump's only way of making money these days. And so, of course, Donald Trump, who we know is a complete and utter treasonous traitor, would do that. But I want to get your take, Popok, about Special Counsel Jack Smith's subpoena here. What do you think the implications are? Do you think there'll be some bombshells, or you think it's just going to be a rehash of what the January 6th committee did?
Yeah. Well, let's start with it this way. The fact that Ivanka, Mike Pence, and Jared are being dragged kicking and screaming into grand juries, we don't know exactly which ones yet, and you've identified at least 3 of them, for me means that we're at the beginning of the end of the prosecutions, not the end of the beginning. You don't bring in these apex people at the very top, you can't get any more inner circle than blood relations and in-law relations for Donald Trump. There's nobody closer to him, probably even than his own wife, than Ivanka. And the fact that she's been dragged, is going to be dragged in, we're going to see if there's going to be an attempted assertion of executive privilege. Although I would argue that it's been waived, because Donald Trump, for whatever reason, strategically, or he's a moron, did not assert executive privilege when they testified about many of these same topics in front of the Jan 6 committee. So I'm not sure he's going to be able to now, like a shield and a sword, I think if you have executive privilege, you need to consistently enforce it and apply it. And if you don't, you don't. And I think he's sort of not able to assert that privilege. And of course, if he tries to assert the privilege, the current holder of the privilege, the current occupant of the Oval Office, Joe Biden, will waive it. And so that will fall by the wayside. Which of the many grand juries, the Jan 6, the election interference, the money laundering / campaign fundraising grift, and the related issues that you identified, Ben, about the connections between Donald Trump and foreign powers, the Mar-a-Lago, as you said, transactional use of documents, I don't know yet. But we do know from the Jan 6 committee and from her other statements, including the video that the Jan 6 committee took special relish in running over and over again to stick it to Donald Trump, was, Ivanka was not only a fly in the wall, but an active participant in some main events in all of these prosecutions. She's in the room, in the dining room, for almost the 3 hours during the dereliction of duty. She's there when when her father calls Mike Pence and uses the P word and encourages him to overthrow the will of the people and not certify the election. She's there for, pardon me, for all of that. She sided with Bill Barr, who called all fraud allegations that Donald Trump was hanging his hat on bullshit. I'm not paraphrasing, that's his words. She agreed with him. To the extent that either this is a grand theater piece arranged by the Trump family, led by Donald Trump, or Donald Trump has consistently attacked Ivanka, leading to her testimony. Because when she sided with Bill Barr, he immediately went on Twitter or whatever social media platform he was on at that moment and said, basically, she's an idiot. She hasn't been in the inner circle for a long, long time. She doesn't know what she's talking about. And she was just being kind or friendly to an old man and Bill Barr who lost it. So he's gone out of his way to attack her and Jared. When she said, I'm not helping, because I think they hoped by leaving their life, their cushy life, their royalty life in New York and relocating to relative anonymity in Miami on an Indian Creek, the billionaire row that she lives on with her husband, building a house there, and leaving all of her friends and her synagogue behind and her social relationships and charitable relationships and trying to start again in Miami with the billions of dollars of grift her family has accumulated. I'm sure they hope by also not helping the current campaign, they would sort of lower the temperature on them, lower the target on them. But that's not going to happen. Like, I hope they don't remember us. We're down here in Florida. And she's been very public in trying to separate herself in a way. We've interpreted this in the past in the New York Attorney General suit, for instance, on the $250 million civil fraud case. She found a way to have Letitia James agree not to have her as subject to financial monitoring as the rest of the family. Eric, Don Jr., Donald, Weisselberg, the rest, because, she convinced the attorney general that she's really out of the business, sort of like Michael Corleone when he moved out west to California, to get legitimate after he left the Corleone family business in New York. Ivanka has tried to convince people that she's gone legit now in Miami and doesn't have those ties. He attacked her even then. He said, when she said, I'm not going to help his campaign, when that reporting came out, Donald Trump got on his Twitter, whatever feed and said, she wasn't asked. In other words, she didn't quit. I fired her. So there's a tension going on here, whether true or made up by the parties. We don't know that yet. But she's in harm's way right now because she's not going to be able to, that executive privilege is going to fall away quickly. She is going to sit in a chair and have to answer questions before prosecutors working for Jack Smith in one of 3 or 4 grand juries. We don't know exactly which yet. We know we know the MO here. We know the blueprint. There's going to be a skirmish over the executive privilege assertion that's going to go currently to Beryl Howell, the chief judge of the court in DC Circuit. We're going to talk about her a little bit later as well in the segment that we're going to do about Pence and others. And then she's going to rule either because Biden has dropped the executive privilege or because there is no executive privilege. It's been waived in the past by Donald Trump. And then she's going to, either have to take it to the DC Court of Appeals and then a fast track to the Supreme Court. But it's not like she's the vice president. The fact that once executive privilege is stripped away from her, which is going to be quickly, she's going to have to testify about these things. And you could be right, Ben. I'm not pushing back much on your financial crimes analysis. Certainly, if somebody were to know about that, the person who at the relevant time periods was front and center in helping to run those businesses. She was very public about it, I'm in charge now. I have the controls. And then Jared's got his own unique problems as well. Pardon me. He tried to separate very quickly, was in Saudi Arabia raising money on Jan 6 because he saw his father-in-law spiraling down the drain and out of control with all these crazy theories and wanted to get away from the bomb blast as quickly as possible. So he's been trying even earlier than Ivanka to get as far away from a destructive Donald Trump, or to paraphrase Fox News and Tucker Carlson that's come out in the Fox files, Donald Trump is a destroyer and we can't let him destroy us. And Ivanka and Jared saw that early on, but now we're going to have to pay the price and testify before all these things. So we'll do that. Are we going to do Pence next?
We're gonna do Pence. We're gonna do Pence next, but you got Kushner, one of the arsonists, out in Saudi Arabia, basically looking for new tools to kind of come back here and to further cause damage to our great democracy. What a fascist traitor that piece of crap is. But I digress. Let's talk about another, though, I think, coward right here, and this is Mike Pence. And look, do you give Mike Pence some credit for the fact that he didn't support the overthrow of our democracy? Well, that's a pretty freaking low bar right there to give someone a pat on the back. Kudos, Pence, you followed the Constitution and you didn't commit multiple felonies, including seditious conspiracy and treason. Certainly not a hero, and I would argue, frankly, a completely spineless coward who enabled Donald Trump throughout and frankly wanted to figure out a way how he could support Donald Trump's coup, but based purely on self-preservation, ultimately didn't. You know, we learn more about his conversations with Dan Quayle, for example, where over and over Pence asked if there was anything he could do. And then Quayle would be like, you have no flexibility on this, none, zero, forget it, just shut up, put it away, Quayle told him. Pence pressed again, quote, you don't know the position I'm in. You don't know the position I'm in, Dan Quayle. You know, and you remember Quayle, like those were the days where someone's reputation in political office would be damaged if you didn't spell potato correctly. You know, now you have Republicans out there just calling for national divorce and secession, and that's platformed. I mean, Quayle's reputation literally shut down on the basis of not spelling potato correctly. But let's go into Pence. We know that Pence was served with a subpoena to testify before the criminal grand jury and to produce documents within the past 2 weeks. We broke that news here on the Midas Touch Network. And then the week after that, Pence stated, well, you know what? I really need to be treated like I'm a senator because you see my ceremonial roles under Article 1 of the Constitution as the president of the Senate. I preside over certain things like the counting of the electoral votes on January 6th. So even though I'm an executive branch official, let's just call me senator, okay? And, you know, there's that thing called the speech and debate clause, which protects or provides immunity for members of the House of Representatives and senators for statements that they make on the House floor, which has been interpreted by the United States Supreme Court case, Gravel, to basically encompass all legitimate legislative activities. So basically, because of my ceremonial role as president of the Senate, I view that as a legitimate legislative role, and therefore everything that's related to the January 6th insurrection, I should not have to testify about. Not because of executive privilege or anything like that, because my role as the president of the Senate. So that was his argument. Fast forward a little bit to this past week. Donald Trump then also asserts the executive privilege, which to me actually may undercut the speech and debate clause claim that he was president of the Senate. If you're trying to assert both, I would think that perhaps in a snarky footnote, the Department of Justice could put that out in the motion to compel. Well, on the one hand, you have Trump claiming executive privilege, which, by the way, the Biden administration doesn't recognize, and which you, Judge Beryl Howell, the presiding judge who's going to make this decision, have consistently ruled against Donald Trump's assertion of executive privilege when he's tried to make it with people like Pat Cipollone, the former top White House lawyer, Patrick Philbin, who is Cipollone's top deputy, Mark Short, Pence's former chief of staff, and Greg Jacobs, Pence's former general counsel. I think you could do a snarky footnote there, Popok, but special counsel Jack Smith isn't playing around here because he immediately filed a motion to compel, and it is what it sounds like. Compel Pence to stop being a spineless coward who is not helping our democracy, and have him testify. And so how do you do that? You file a motion with the presiding judge, Judge Beryl Howell, who presides over the criminal grand juries, all of the criminal grand juries in Washington, D.C. Her term is set to expire on March 17th, but she's held this role for some years. So any criminal grand jury, and because these are criminal grand juries that exist, the ones investigating Trump's criminal conduct, she's the decision maker there. All of her previous rulings have mostly all been in the favor of the Department of Justice. And here, Jack Smith is saying, look, compel Pence to sit before the grand jury. Ultimately, Pence can appeal to the D.C. Circuit Court of Appeals. And he could appeal ultimately to the United States Supreme Court. But Pence, the first layer of decisions going to go with Judge Beryl Howell there. And before I pass it to you, Popok, I think here is the arguments that I think I make in this order. One, no executive privilege. Judge Beryl Howell, look at what you've ruled previously with Cipollone and Philbin and Short and Jacobs. Former presidents don't get to assert it. Sorry. Biden hasn't asserted it, and there's a compelling need in any way. Let's dispose very easily of the executive privilege. You move over to the speech and debate clause immunity. First off, Pence isn't entitled to it. He was a vice president. He's not a senator. The speech and debate clause clearly just refers to members of Congress, senators, and members of the House of Representatives. He is neither. In any event, even if you claim that he has some level of speech and debate clause claim, it should only be in the moment when he is acting in that ceremonial role. And here we are looking for all of this other information leading up to the insurrection, the day of the insurrection, when he was not doing a ceremonial role, what he heard and what he observed. And then my third argument is that we know that the speech and debate clause also does not apply to things that are not legitimate legislative activity. And you observing people overthrowing democracy is not legitimate legislative activity. And there we can think about when Lindsey Graham, senator from South Carolina, tried to assert speech and debate clause immunity in a later topic we're going to talk about, which is Fani Willis's criminal investigation before the special grand jury in Fulton County, where Graham asserted speech and debate clause immunity, and the district court, the Ninth Circuit, and ultimately the Supreme Court basically said, look, there may be areas that are legitimate legislative activity, but when you made these comments to the Secretary of State and to others, you were not engaged in legitimate legislative activity. You were extorting them. That could be, viewed as that was certainly not legitimate legislative activity. And statements to the press are not legitimate legislative activity. So, Popok, what do you think?
All right, let me see what I could advance here, as we covered a lot of ground on that one. First of all, let's start with the lawyer that represented Pence when he had to make all decisions about, besides getting advice from Dan Quayle, Greg Jacobs brought in J. Michael Ludwig, a conservative, well-respected, now retired federal judge, often referred to as the father of the Supreme Court modern, because many of the people that served there came through as clerks of Ludwig, and he has close relationships with people on the Supreme Court. He just published a guest essay in the New York Times just the other day. It's under the title, A Conservative Case for Avoiding a Repeat of January 6th. But within it, he is taking his former client, Mike Pence, to task, who he told in no uncertain terms, just as Quayle said, but this is with the imprimatur of being a federal judge, former federal judge, well respected. You don't have any powers here, Mike. You can't do what Trump is asking you to do. You're ceremonial. You watch envelopes being opened, you bang a gavel, and you declare a winner, and that's it. And this other fake elector stuff and all the other things you're being asked to do, you cannot do. And it's public from the Jan 6 committee testimony through Greg Jacobs and others that Pence relied on that advice in not helping to overthrow America. Now, that same judge/lawyer is taking Pence to task in public. He even says one of the reasons he wrote the guest essay is to put pressure on Pence to realize that this Hail Mary defense of speech and debate or executive privilege that he is putting up, and this is in Ludwig's word, Hail Mary pass, is going to be shredded really, really quickly. And since you're running for office, or you want to run for office as the president of the United States, if you think you're going to time this thing out and push it so far off into the future that you won't have to be dragged into the grand jury until well after like the primaries, that's not going to work, because this is on a fast track. First stop on the train is, as you said, Ben, if it happens in March, which it will, is Beryl Howell. Beryl Howell, who the Department of Justice is batting like 950 in front of. These are beyond Hall of Fame numbers in winning every time. So Beryl Howell, prediction, she's going to rule against Mike Pence. Trump is going to assert the executive privilege as he has. She's going to analyze it. And the Department of Justice is in an interesting position. And they're being very nuanced in the executive privilege issue, but we'll focus on that for a moment. In some cases, and we're going to talk about it when we get to Strzok and Page and the former FBI people that were also in a relationship who are suing to get their jobs back because they were fired by the FBI under Trump because they were, anti-Trump in private. There, the Department of Justice is actually, in a way, on the side of Donald Trump, but on the side of executive privilege. And there, Amy Berman Jackson, we're going to talk about her later, she wants to hear what Joe Biden, current holder of the executive privilege, has to say about that. So it's not that the Department of Justice is always stripping away executive privilege. Sometimes, as we've said, politics and law make strange bedfellows. Sometimes it's sort of they're on that side of the Trump side because they have broader historical considerations to make when they're doing their litigating in the courtroom. But here it's clear. Mike Smith, I made a new person. Jack Smith's going after Pence. It's going to happen in the next couple of weeks. It's going to get in front of Beryl Howell. It'll probably be one of her last things that she does before new judge Jeb Boasberg takes over, also a Democratic appointee. So we shouldn't have too much fear about that he's going to throw over the apple cart that's been established so delicately by Beryl Howell in precedent over the last year and a half or 2 years. So that's looking pretty good. If he doesn't like the result there, he can take it up to the D.C. Court of Appeals. We'll have to see the panel. Usually it skews Democrat. Could get one Trumper or Bush person on there or so, hopefully. And then it goes to a Supreme Court, which, although has been not where we want it to be, that's an understatement in terms of its rulings on most major issues. When it comes to presidential papers, politics, executive privilege, testimony, Jan 6th, it looks like we got the votes to force Pence to testify, but we're going to have to watch this closely. But I agree with you. This whole speech and debate thing, maybe it covers, because you can have overlapping privileges and then kind of seams and gaps where there is no privilege over a timeline of events. So in other words, there may be a little bit of privilege that's properly asserted over the day he stood on Jan 6th or things around him on the floor of the Senate, presiding over in ceremonial ministerial fashion only, the opening of the envelopes and the ballots and the counting by state. Maybe if there was like a conversation he had, if he put his hand over the microphone, if he talked to some legislators there about process, if he was getting some consultation about his role at the time, maybe it's covered, maybe. But other things let's talk about you getting a phone call from Donald Trump where he called you a pussy because you didn't have the balls because you weren't willing to pull the trigger on his fake elector scam. What's that covered by?
You're saying that is part of your role as the president of the Senate is to be called the P word by the president?
Right. So that's out. And so maybe that's executive privilege, that interaction between the two of them, and if there was an attorney in the room, maybe attorney-client privilege, but they're going to have to, just as she's always done, just as we have a lot of confidence in her abilities to do, Beryl Howell will pick through, just as the Northern District of Georgia did, which is now 11th Circuit precedent affirmed by the U.S. Supreme Court under the case of Lindsey Graham, as you mentioned, about when it's appropriate and when it's not appropriate. He is going to have to testify. It's going to be about many of the events the part about why didn't you get into the things that came up in Jan 6th? Why didn't you get into the car and get whisked away from the Capitol where the Secret Service tried to duck your head into a moving car?
What's he going to say? It was just me doing my legitimate role as the president of the Senate. All presidents of the Senate.
Right. So that doesn't work. These are the examples that you and I are providing to show when there are some events that are important, that are covered, not covered, may be waived, and overarching the criminal investigation of obstruction of justice. The criminal case against Donald Trump will likely overcome many of the assertions of these privileges. They're not absolute. They're always balanced against the need of the justice system to get to the bottom of things. We've seen it time and time again by federal judges with Eastman, with the crime fraud exception ripping away attorney-client privilege, with executive privilege being dropped by Biden when asked. We're going to, this is the message, I believe, that the conservative J. Michael Ludwig was trying to send through the New York Times guest essay just a day or so ago to his former client. You're going to lose this, and you're going to look terrible in history along the way. And if you think you'll be able to delay it long enough, this Hail Mary pass long enough, in order so it doesn't impact your presidential ambition, you are wrong. Step up. Be the patriot, because Ludwig was the first one to come out and say, early on, he should be given a lot of credit, my client, for doing the right thing. Yeah, that's not what he's saying now in the essay.
And I think that Ludwig really has two audiences that he was trying to reach there. The first audience was an audience of one in Pence. The other audience was an audience of the few, which are the judges who are going to be hearing Pence's assertion of speech and debate clause immunity. And many of these judges worked for Ludwig, and he wants them to know as well what Pence is saying is complete and utter BS right here. And with all of this news of the criminal investigation heating up by Jack Smith, Donald Trump is just completely losing his mind. This is what he posted earlier in the day on his social media platform. He goes, "The DOJ didn't need a search warrant for my home, but they did need it for Biden, who has not been forthcoming, had no rights to declassify, had no security, all in caps, in many different locations, even Chinatown. He won't give the 1,850 boxes of documents stored in Delaware. Why not? I have done everything correctly under the Presidential Records Act. He didn't. As president, I had the absolute right to declassify, not Biden. Unfair and unequal treatment under the law. Fourth Amendment violation, and more." You don't get more treasonous and traitorous and just have more disinformation in a single post than that. And he injects this disinformation into the cult followers who listen to him each and every day. And it's parroted on Fox and all these other right-wing treasonous networks out there. When he goes, "The DOJ didn't need a search warrant for my home." You mean after essentially 2 years of you lying and having lawyers submit fake declarations, false, fraudulent declarations, saying everything was returned when it was not?
And moving the boxes around.
He goes, "But they did need it for Biden, who has not been forthcoming." You mean the person who said that you can voluntarily search all of my properties, that you don't need a search warrant? Whereas Trump said, "I'm not going to let you search." And Biden said, "Search all of my properties." And by the way, Pence said the same thing, "Search all of my properties." And then he goes, "Even Chinatown," he has to throw in some like bizarre racist conspiracy theory and it puts Chinatown,
What is that one, Ben? I don't get the Chinatown reference. What is that?
I don't get it.
Right.
Either.
Okay.
He's made some conspiracy theory about records before in the George H.W. Bush administration, that it was held in a location, in a building that was later rented out by the National Archives that once had a Chinese restaurant in it. So I don't know. I don't know if that's what's in his, in his mind. And the building also once had a bowling alley. So the one thing he was saying is they kept it in a Chinese restaurant and bowling alley. But no, it's like it's like a petulant third grader with racist parents, who then goes into school and just starts saying things, and you're like, "Where did you get that, Jimmy?" But this is a former president. It's sick. I mean, it's disgusting what he's saying. And then when he goes, "I did everything right under the presidential record." No, you literally did everything wrong. And he took the advice of Tom Fitton, who's not even a lawyer, and you believe there's no crimes when a magistrate judge found that there was probable cause of Espionage Act violations, obstruction of justice, concealment, and mutilation. And then when you go, I had the absolute right to declassify. First off, you didn't declassify. There's a process of declassification. I've argued that if you did declassify these telepathically, as you said, it makes it worse because you didn't go through a process, and now you've placed our troops and our national security and foreign assets at risk, many who may have been killed by you telepathically declassifying things and not telling the national security advisor, Robert O'Brien, at the time. But setting that aside, the crimes here have nothing to do with classification. They have to deal with you stealing things that don't belong to you because you're not the freaking president. Popok, your reaction?
And I got one comment on that from a slightly different angle, but kind of consistent with what you're talking about. Let's talk about it from a practitioner standpoint, you and me. I will tell you from experience what happens when you continue to poke the prosecutors and taunt them, which is what this is the equivalent of. This constant taunting of the prosecutors in tweets and social media only pisses them off, makes them focus more on their job, and makes them want to bring you down harder and faster. Jack Smith has eyes. His people know about the same social media tweets that you and I just talked about. And all it does when he taunts them and pokes the bear, and I've had situations where I lost a little bit of control of a client who decided to, not through social media, but otherwise, take on the prosecutor. And all it did was so poison the discussions with the prosecutor that we almost couldn't get them to engage in any kind of discussions that were beneficial to the client at all because of what they've done. And that's what's happening here. It's not that they're immune to all of these things. It's that they read them and say, you know what? Now I'm going to really, they were already connecting the dots. They were already putting the links of the chain together for the improper, illegal moving of documents from place to place under video surveillance after promises and representations were met to the Department of Justice that there would be no movement of the boxes from as long as we're talking about Chinese restaurants and bowling alleys, from the pool hall, from the pool room of his Mar-a-Lago, in which everyone had access who were ever guests at Mar-a-Lago, from the ballroom and from the pool area, including that Chinese national woman who wandered around at the very same time the documents were supposedly secured in an unlocked room, and Lord knows what could have happened. That's why he got the execution of a search warrant in an unprecedented, because his behavior is unprecedented. If he had turned it back, as you said, along the 2-year timeline at any time along the way and hadn't misled with Christina Bob's bullshit certificate, and then we're even finding today the aide, the female aide who is yet to be identified, with the laptop with the documents that were loaded up because somebody that was his chief of staff post leaving office told her to do it. This is still going on. They're still finding boxes of documents because of his sloppy, careless, treasonous approach to our national security secrets. The presidency was a joke for Donald Trump while he was in office, and it's a bigger joke now that he's left. And until he's taken to task, and until the law is applied equally to him, which it is in terms of the ongoing grand juries. I know we all want the indictment. Nobody in America or around the world wants a show today, to you and me, to be devoted to talking about an indictment of Donald Trump somewhere in America more than you and me. And we still have reasonable confidence that somewhere it's going to happen. We'll talk about Fani Willis in a little bit, but somewhere it'll happen.
Well, I'm sure that you and I are tied with about 90 million other Americans who can vote now about that same desire. So I'll say it's a 90 million person tie. We've got a lot to discuss here on the Midas Touch Network, including how the former Republican Attorney General of Arizona tried to cover up and did cover up until a new Attorney General came in. A report prepared by the office showing no election fraud in Arizona in order to help the treasonous traitor, Donald Trump. I want to talk about how a federal judge has ordered Donald Trump to sit for a deposition in the Peter Strzok wrongful termination lawsuit. And I also want to talk about what in the world is going on in Fulton County with the foreperson speaking out, with the presiding judge saying it's okay, with Phony Willis saying charges are imminent, but imminent to me usually means like now, like about to happen. So what is going on there? Popok and I will give you our thoughts. But first, a word from our sponsors.
And now let's take a quick break to talk about our next partner, ZBiotics. You ever skip a workout because of drinks the night before? Well, me too. If you're committed to your healthy routine this year, you need ZBiotics. ZBiotics Pre-Alcohol Probiotic is the world's first genetically engineered probiotic. It was invented by PhD scientists to tackle rough mornings after drinking. So here's how it works. When you drink, alcohol gets converted into a toxic byproduct in the gut. It's this byproduct, not dehydration, that's to blame for your rough next day. ZBiotics, it produces an enzyme to break this byproduct down. It's designed to work like your liver, but in your gut where you need it the most. Just remember to drink ZBiotics before drinking alcohol. Drink responsibly and get a good night's sleep to feel your best tomorrow. The first time I tried ZBiotics was on vacation with my wife. As instructed, I drank a bottle of ZBiotics before any alcohol, and I was amazed at how good I felt the next day. Give ZBiotics a try for yourself. Go to zbiotics.com/LegalAF to get 15% off your first order when you use LegalAF at checkout. ZBiotics is backed with a 100% money-back guarantee. So if you're unsatisfied for any reason, they'll refund your money, no questions asked. Remember, head to zbiotics.com/LegalAF and use code LegalAF at checkout for 15% off. Oh, hey, I didn't see you there. Look, everyone knows how annoying cheap razors are. The cuts, the irritation, the frustration. And don't get me started with subscription razor services, the headaches that those can cause. That's why you gotta meet Henson Shaving. Henson Shaving is a family-owned aerospace parts manufacturer that has made parts for the ISS. That's the International Space Station and Mars rover. And now they're bringing precision engineering to your shaving experience. Razor blades, they're like diving boards. The longer the board, the more wobble. The more wobble, the more nicks, cuts, and scrapes. A bad shave, it isn't a blade problem, it's an extension problem. By using aerospace-grade CNC machines, Henson makes metal razors that extend just 0.0013 inches, which is less than the thickness of human hair. That means a secure and stable blade with a vibration-free shave. It gets better. The razor has built-in channels to evacuate hair and cream, which makes clogging virtually impossible. Seriously, Henson Shaving wants the best razor, not the best razor business. That means no plastic, no subscriptions, no proprietary blades, and no planned obsolescence. The Henson razor works with standard dual-edge blades to give you that old-school shave with the benefits of new-school tech. Once you own a Henson razor, it's only about $3 to $5 per year to replace the blades. My first shave with the Henson razor was incredibly refreshing. The design is sleek and the durability is top-notch. The Henson razor is truly so much better than your run-of-the-mill quote-unquote traditional razor brand. And the affordability factor is absolutely game-changing. No more wasting your money on expensive blades. With Henson Shaving, you can get a year of blades for just $5. Okay, so this is what you have to do. It's time to say no to subscriptions and yes to a razor that'll last you a lifetime. Visit hensonshaving.com/LegalAF to pick up the razor for you and use our code LegalAF and you'll get 2 years worth of blades free with your razor. Just make sure to add them to your cart. That's 100 free blades when you head to hensonshaving.com/LegalAF and use code LegalAF. And now back to the video.
And welcome back to the Legal AF show. I'm Ben Meiselas and Michael Popok. A lot to discuss. We've got 3 important topics that we want to make sure we hit. The first one is how the former Attorney General, Republican Mark Brnovich, covered up a report that their office prepared that shows that there was no election fraud in Arizona and covered it up for Donald Trump. Then I want to talk about how a federal judge in Washington, D.C. ordered Trump to sit for deposition in the Peter Strzok wrongful termination lawsuit. Then we got to talk about what in the world is going on in Fulton County with the four-person speaking out to the media, the presiding judge saying it's okay. Popok and I will break it down. But Popok, I've been doing a lot of talking on this episode, and I see that in the chat, people are saying, let Popok speak a little more. So let me throw this one to you, Popok, which is Chris Mays, the new attorney general, Democrat, comes into office in January. She's aware that her predecessor, a Republican, talked about doing this investigation, talked about preparing this report about whether or not there was election fraud. We all know that this guy Brnovich, this Republican attorney general, had gone on the Bannon show, had done other right-wing networks, and had said very negative things about the Arizona election process. And Chris Mays, the new attorney general, wanted to get to the bottom of it. Was Brnovich lying to the public? Did he prepare a report that he hid? Michael Popok, what happened here?
Yeah, yes, he did. And this should come as no surprise. You and I have some people might be like rubbing their eyes and poking at their ears because they might be like, didn't we already learn this already? You learned something similar. We talked a couple of weeks ago about a Trump paid for and sponsored report that looked at Arizona and other battleground states, for which Trump paid $600,000 to Berkeley Research Group, and they found that there was zero fraud on many of the same grounds, such as dead voters voting, no, people voting out of precinct, maybe a couple of times, not enough to change hundreds of thousands or millions of votes in favor of Joe Biden, software corrupted to flip votes to Biden from Trump, no. And we talked about that at length. And the reason that was important at that time, because that was a direct link to Donald Trump and his criminal mind or mens rea, because there was a presentation of the fact that none of your working theories, Mr. President, are borne out in our detailed research that you've paid for. And Mark Meadows was in the room for that discussion with Donald Trump. Here we have what we always thought, which was cyber ninjas was full of, poopy. Cyber ninjas who, during what you and I used to jokingly refer to a year and a half ago as the fraudit in Arizona, hired by the Republicans of the Arizona legislature to do some sort of, fraud investigation related to the election, using not the attorney general of the state's special investigation section and an election integrity unit, which is what a state would use, but hiring these bozos out of Florida who had never done a election investigation in their life before, no competitive bidding. They were just like, oh, we like your name, Cyber Ninjas, you're in. And Cyber Ninjas comes in and throws up all of these things that we reported along the way that, like bamboo on Korean ballots that were brought in, 100,000 of them with Biden's name printed on them in favor of voting for Biden, and dead people voting and all this other stuff that we've talked about. It turns out even Cyber Ninjas found out that there was irregularities, but they actually figured out that there were more votes for Biden, not less, when they finally did their math. That's Cyber Ninjas. This is now the Attorney General Republican who does on his own. He commissions, and we got the report up there now. He commissions the Special Investigation Section of the Criminal Division of the Office of Attorney General. What a great sounding name! And a chief special agent who prepares this report, which is issued in September of 2022, which we never hear about. This 11-page report in which they basically methodically went through every lead, every report, including Cyber Ninjas, and they concluded that there was absolutely no evidence. In fact, everything that Cyber Ninjas, and I'm paraphrasing, although Salty may be able to find the quote, everything that Cyber Ninjas said was inaccurate and false, including, so they went through the dead voter issue. First, they found that Cyber Ninjas relied on a public database that is historically notoriously inaccurate and that nobody in the public world or in the investigative world uses, and that was their basis. They found that they're out of the hundreds of thousands or millions, and to remind people, this is the same state as Kari Lake. This is the same state that Ben has talked about on Hot Takes, and we've talked about on LegalAF, that there was voter fraud. Okay, this is the Attorney General of the state Republican and his department independently, credibly writing. And this is what, Ben, out of the hundreds of thousands of dead people voting, do you know how many total they found in this report?
How many?
0. Of the people double voting, again, Carrie Lake's talking point, hundreds of thousands, millions of people double voting. Guess how many they have found? One. And this is a state where Biden won by over 10.
I see it coming up on the screen.
This is a state where Biden won by over 10,000 votes. One. Okay. Again, back to what you and I have said in the past. It's not that there's no election fraud, if you want to call some of these things fraud, state by state, nationally. There always is. It's just never enough to overcome.
Popok, just one more thing. All the double voting is usually always by the Republicans who triple and quadruple. Whenever you find out who they are, they're always Trump bagging.
But there was one, and I don't know. I mean, I sometimes I didn't pay attention in grammar school math, but one is less than 10,000. They also said that, and Cyber Ninjas wasn't the only one. There were these other BS groups that popped up, Fair Election Integrity. They all made up names, these, garage band groups that pop up. They went through every one of them and found nothing. They said there were 450 or more open investigations that led to, I believe, let me get the number right, 22 prosecutions for anything related to election integrity. 22. Okay, Trump had to come up with 10,000 in order to win the presidency. 22 does not do it. And so what does this Republican do? This is where elections have consequences. He buried the report because it wasn't helpful to their narrative. It wasn't helpful to their lies to the American people. It wasn't helpful to the fundraising because he was running for Senate. Brnovich ran unsuccessfully for Senate in Arizona. And so he didn't want this millstone around his neck hung around him. So he buried it. But he should have thought ahead that if he lost, it was an open seat for the Attorney General because he ran for Senate. In the open seat, the Democrat won. Democrats won a lot of things in Arizona, including the governorship. And so the first thing the guy did, the woman did that became the Attorney General was like, ooh, look at this nice report. Let me publicly disclose it. Sunshine, disinfectant, doctrine by Ben Meiselas. Let me bring it out to the world. And here it is. So combined with Berkeley Research Group reporting directly to Donald Trump, for which he paid $600,000, telling him there's no Arizona fraud. Arizona concluding there's no Arizona fraud. And if anything, the Biden got more votes after the audit than before the audit. Can we now, once and for all, Twitterverse, not our people, not our followers, lay to rest the argument that there was voter fraud anywhere in Arizona? Yet while you and I are talking about this, the big lie, which is the big lie that Joe Biden only won through fraud, is going strong in places like Michigan, where the GOP has been completely taken over by election deniers. So this is still this is the problem that Ludwig talks about in his guest essay, that we are letting the Republicans are allowing their entire narrative and their entire tug of war of who they are as a party to be pulled completely over to QAnon election deniers, which means they are doomed to failure in terms of future electoral success at a national level. Do you hear me, DeSantis, or anybody else that falls into that plot?
Popok, should Mark Brnovich lose his legal license for what he did here? I'll tell you, I believe that he should. A number of very prominent lawyers in Arizona have filed letters with the state bar to disbar him as a lawyer. And he's acting in capacity as a lawyer, as an attorney general. You have certain duties of candor. You still have duties of zealous representation. You have to be truthful and honest. You can't commit fraud. And he had obligations, and I think it was a fiduciary to the public in that position. And it wasn't just that he concealed the report. It was that he then went on shows like Bannon and said, well, we all know what happened in 2020. And then he made other statements basically calling out the election process as being completely dysfunctional. Meanwhile, he had this report. One final point I'll make before getting your thought on whether he should be disbarred is that, look, Brnovich knew this sooner also. I mean, he knew it right away. And I think he dragged out the preparation of this report until the last possible moment anyway, September of 2022, when this report could have been prepared. If he knew, put it this way, if the results were the fraudulent narrative they wanted to push, they would have had a report out immediately. And when the report didn't go their way because the truth was not their way, they dragged it out and then tried to bury it. And then they desperately hoped that a Democrat would never become the attorney general there. And then, by the way, they fought and continue to fight to this day, these MAGA Republican election deniers, to try to claim that Chris Mays wasn't elected appropriately and that there was election fraud and there was a conspiracy and that's how Chris Mays was elected, even though the courts rejected that. Should he be disbarred, Popok?
The land of John McCain. What has happened in Arizona? Oh, how the Republican Party has fallen in Arizona. And by the way, back to your constant refrain on the Midas Brothers pod. Elections have consequences, and this is why you and I, and on your podcast, we talked about why it's so important to get people like, the former astronaut, what's his name, that became the senator in Arizona, that guy, elected, because they hoped, as you just pointed out, that this stuff would get buried and we would never learn. History would never learn. On the disbarment thing, yeah, I mean, look, states like Georgia, which we'll talk about soon, and Arizona do have statutes where it's a crime to make a false swearing, where you go on a show like Bannon and say, well, we all know that there was, those Korean ballots with bamboo on them, which, by the way, they actually looked at in this special investigative unit that issued the report. And they said there was like one person who reported that. And then she said, never mind. It was based on, there was no evidence of this, but that narrative of 100,000 ballots being brought in from Korea with bamboo on them, that was promoted by cyber ninjas, it consumes so much oxygen for so much time that you and I had to like a whack-a-mole had to hit it down, and rather than talk about other things. But I think that's a false swearing. I think that is a violation of, he either doesn't commission the report and then buries it, and it doesn't have to bury anything, and so there's no crime. Or if he commissions the report, but for the reasons that you've outlined, to feather his own nest, to promote his own political ambitions, to go on, and because he wants to win the Senate, and bury bad facts that aren't in his favor, that sounds like it's violated at least 2 to 4 different rules of professional responsibility as a lawyer, as the chief legal officer of the state. And I'm sure if it hasn't happened already, somebody's going to file a bar complaint against that guy, and we're up and running. And I would hope that in Arizona, they take something like that seriously. I was shocked, just to bring it kind of around, the only lawyer so far that's in Trump's inner circle that has been able to avoid disbarment is Sidney Powell in Texas, because she pulled a MAGA Trumper Republican judge who just ruled in her favor and found that the Texas bar didn't meet its burden, even though we were like, how could that possibly be? Every other state, New York, Washington, and different places have found that all those lawyers promoting the big lie and filing those documents committed multiple violations of professional responsibility misconduct. And Texas, of course, found that she's okay. She's okay as a bar member there. So look, I don't know we'll have to research the Arizona court system enough to know what would happen off of a bar complaint, because it's ultimately going to go to a judge.
Senator Mark Kelly, the former astronaut, former Air Force, Mark Kelly was an incredible senator out there. This is why this show matters, though, as well, and why the law matters is because the legal system, fortunately, and the court system held, even though MAGA Republicans took over a political party. If you had MAGA Republicans leading the House of Representatives, I think you would have had a different result in the 2020 election and would have had a real constitutional crisis, because they would not have allowed the certification process to take place. But fortunately, the courts held, despite the fact that MAGA Republicans tried to destroy it, and they continue to want to destroy these institutions. There have been a number of lawyers who have filed bar complaints against Mark Brnovich. And as we have these conversations, and I'll just digress just for a 1 minute, I'm reminded by the term banality of evil by the philosopher Hannah Arendt, which she famously coined in the 1960s. And she wrote this article in the New Yorker in 1961 about Adolf Eichmann, who's a Nazi operative who was responsible for organizing the transportation of millions of Jews and others to concentration camps. And what Arendt had said about Eichmann, using this term, the banality of evil, was that Eichmann was ordinary, bland bureaucrat who, in her words, was neither perverted nor sadistic, but terrifyingly normal. He acted without any other motive other than to diligently advance his career in the Nazi bureaucracy. And that was ultimately her case study in 1963, Eichmann in Jerusalem, a report on the banality of evil. But there is a level of this MAGA extremism, of sadism, of sadistic. It's not terrifyingly normal. They want to make it terrifyingly normal, their behavior, and it is incumbent on the pro-democracy community to ensure that the banality of this it does not become the reality of it, that we do not get so jaded by the conduct to allow that to become the banality of evil. We need to call it out for the fascism that it is. I want to turn right now, though, to a decision by a federal judge in Washington, D.C., a judge who we've talked about here before, Judge Amy Berman Jackson. In a minute order at the end of last week, she ordered Donald Trump to sit for a deposition in the Peter Strzok wrongful termination lawsuit that he filed against Bill Barr, the Department of Justice, the FBI, and some others. She also ordered Christopher Wray, the FBI director, who was also then the FBI director as well, to sit for a deposition. She's limited the scope of the deposition and the timing of the deposition to 2 hours, which is not unusual when you're dealing with what's called apex individuals. In her minute order, she talked about the apex doctrine, which generally holds that an apex individual who's at the highest level, like the CEO or the president or someone who heads a massive division within the government or company, that if they're the apex, what you have to make a showing of if you're seeking their deposition is that you have exhausted all other options before going to the apex individual, or that the apex individual holds very unique information that only they can provide, and that's why you have to depose them. And here Peter Strzok is absolutely able to show that, in the sense that the FBI had previously just recommended a 60-day suspension for Peter Strzok. He was their top counterintelligence investigator at the FBI. By the way, someone who was investigating Hillary Clinton for her laptop. And so he was always assigned to whatever counterintelligence task the FBI was investigating, and the most politically charged and inflamed he would often be involved in by the nature of being the top official there. And then he was Mueller's top FBI investigator in the Mueller probe. It was learned that he was having an affair with Lisa Page, who's an FBI lawyer. And then the Republicans subpoenaed his text messages going back to 2015 and 2016, which showed, one, that he was having an affair, which Donald Trump and everybody made sure to kind of mock that and make that a prominent aspect of their attack on the FBI in general. And his messages showed that he was not a fan of Donald Trump back then, at the time that they were also aware that Donald Trump had links with Russia. And if you are truly law and order and you see Donald Trump cozying with the Russians, you would not like Donald Trump. And Peter Strzok's has done numerous television appearances, including here on the Midas Touch Network, on the Weekend Show, where he's discussed that, no, I mean, I believe that Donald Trump is either an asset or is controlled by Russia, because all of his actions are very consistent with that. But Trump basically overrode the 60-day suspension, made sure Strzok was suspended immediately. That's why ultimately Trump, as an Apex employee, gets to be deposed here, with one proviso, and this is what I'll just toss it to you, Popok, so I won't cannibalize the topic, but there was provisos and limitations that Judge Amy Berman Jackson gave in addition to time, where she kind of tossed the issue to the Biden administration here. So talk to us about that.
Yeah. This is what we anticipated earlier in the podcast today about the DOJ's nuanced assertion of executive privilege, or having the president, Joe Biden, assert executive privilege. This was actually a motion by the Department of Justice to not have Donald Trump and Christopher Wray, the current FBI director, testify at all. And they argued in that, so that's who brought the motion, asserting executive privilege over these very issues. And Amy Berman Jackson held a hearing, which we know a little bit about, but again, a secret, closed, sealed hearing over these issues to protect the privilege until she's made her final decision, about whether, Peter Strzok and Lisa Page are going to be able to ask questions of Donald Trump and Christopher Wray about what happened to their career as it was dashed at the FBI after both their affair and the emails, personal emails between them and text messages, came to light through the Republicans and then disclosed through Trump and them to the press. I mean, listen, they're allowed to both be in the FBI and be a member of a political party. Let's just get that on the table. They are allowed to have opinions. If Strzok wants to write his girlfriend or his relationship and say F Donald Trump, even though he's assigned to a matter through the Mueller investigation as one of the head counterintelligence people at the FBI, and that involves the investigation of Donald Trump, that's okay. I agree with Strzok's position that he continues to have a First Amendment right, despite him being in an investigative position with the FBI. Lisa Page is making a slightly different argument, although similar, that there was a privacy act, a federal privacy act that was violated because her personal emails and texts were ultimately disclosed to the public that never should have seen the light of day. But, just as Trump retaliated against your podcast co-anchor Michael Cohen and forced him to stay through the Bureau of Prisons in prison longer than he should have, and Michael successfully litigated that issue, I think ultimately Strzok and Page are going to be able to testify and successfully prove that their careers were dashed improperly and illegally by Donald Trump throwing his weight around to attack them because he didn't like the result. Look, this is not the first FBI agent that we've heard about. There's one that's currently sitting in federal detention center and has been indicted related to the Russia investigation. This is probably this is at least the second one. And the reality is, let's just call it what it is. FBI agents are allowed to have political opinions. It shouldn't infect their job, just as I have my own political legal opinions. People hear about them 6 or 8 times a week, yours too. But when I represent a client, that doesn't impact what I'm doing for a living. And as an investigator, I wouldn't think it does either. And I think it's very interesting, as you noted, that Peter's been on different platforms, including your own, the Midas Touch Network, to say that he does believe, as others do, that Donald Trump is an asset. And if he's not an asset of the Russians, he certainly operates like he's one and acts like he's one. So I think he's going to be successful in his career. But Amy Berman Jackson has given the Department of Justice until the end of March to come back with the Biden, whether Joe Biden, President POTUS, is going to waive executive privilege or not. And she said, for now, the only thing I'm ruling on is whether under the apex deponent person doctrine, there is an exceptional need for this information that can only come for people sitting at the apex at the top, Christopher Wray and Donald Trump. And I find for that limited purpose, for the questions that they want to ask, which only Amy Berman Jackson and the lawyers and the parties know at this moment, I'm going to give you 2 hours with Christopher Wray and Donald Trump on this particular issue. I have not reached yet a conclusion about what you can do about the executive privilege issues and other issues. That I have to hear from the Department of Justice and ultimately Joe Biden come back to me by the third week in March, and we'll have another hearing. So there is going to, as you said, and as we say here in our little lower third, there's going to be a deposition of Donald Trump. The total scope and parameters of it, not yet decided by Amy Berman Jackson.
So two things I want to point out. First, you mentioned the other FBI agent. Just give some context there. Charles McGonigal, who was a special agent in charge of the FBI's counterintelligence division in New York from 2016 to 2018, who was accused in an indictment recently of working with a former Soviet diplomat turned Russian interpreter on behalf of a Russian oligarch very close to Vladimir Putin to aid and abet Putin's agenda, including essentially covering up for Putin's relationship with Donald Trump. And so when we talk about McGonigal, these are the types of people that Peter Strzok was trying to investigate. Peter Strzok is the good guy because in America, we don't support our enemies, the bad guys, Russia, who are trying to destroy us. So one of the things that Donald Trump tries to do, and the MAGAs tried to do, the MAGA Republicans, by creating all of this disinformation, is to try to merge. Look, there's just a lot of bad FBI people out there. You got Strzok, you got McGonigal. Look at the FBI, deep state. No, there's a very deep distinction here. There are FBI agents who are trying to find the bad guys, like Strzok. And then you have the FBI. So you have some people who may be actually agents, foreign agents who have infiltrated, who are the bad guys, like a McGonigal. And a McGonigal was trying to cover up for Trump, which Trump goes, look at this FBI. No, McGonigal was your guy. McGonigal was covering up for all of the stuff that you were doing. And then when Trump goes, oh, there was no there with Russia, Ukraine. He says the words multiple times over and over and over again, because that's part of the way, you spread your big lie. Let's not forget the head of Donald Trump's campaign was convicted. That person Donald Trump put at the top of the NSA was convicted. I mean, two of the most highest level people were convicted based on... You're talking
about Manafort and Flynn.
Yeah, based on their relationships with Russia and a host of others. And ultimately, Mueller didn't have the guts to indict a sitting president. It is a very different dynamic that Trump is no longer the president. I want to make one prediction, though, that I do not think our legal AFers will like, but I always tell the truth here on Legal AF, and that is I think the Biden DOJ is going to assert executive privilege here. And let me explain to you why. I've been weighing it. I was 50-50 on it when I first saw the minute order, but as I've been doing more research on it, I'm fairly confident now that the executive privilege is going to be reluctantly asserted. Let's remember, the Department of Justice, not only do they not give a shit about Trump, they're criminally investigating Donald Trump. But with these unprecedented natures of having a former president who is a criminal, the Department of Justice still has to follow prior legal precedent, which people like the MAGA Republicans want to completely tear and shred and manipulate. So you have this difficult situation where the Supreme Court held in 1982 in the case Nixon versus Fitzgerald, which was a wrongful termination case brought by Fitzgerald against Nixon because Fitzgerald spoke out in public hearings against Nixon, and Nixon fired Fitzgerald for his role in the government based upon his public statements. Fitzgerald sued Nixon, and the Supreme Court said presidents have absolute immunity, even from unlawful acts, like wrongful termination, provided it is during their presidency and it is still within the scope of their constitutional duties. And so the distinction here, whereas the Department of Justice has not, as the current Department of Justice has not asserted executive privilege relating January 6th issues because they've taken the position that's outside the scope of constitutional duties. overthrowing the government, not constitutional, not subject to an executive privilege. And in any event, Trump was engaged in campaign activity, political activity, outside of constitutional duties of the executive branch. But what Nixon v. Fitzgerald said, because executives, the commander-in-chief and the president as his role, essentially as the chief executive of all departments, has hiring and firing power, even if a president wrongfully fires somebody, can't sue Nixon. So unfortunately, and again, I'm just telling you what the legal precedent is, and knowing Merrick Garland, he will probably, based on Nixon v. Fitzgerald, assert it here the same way he asserted it with E. Jean Carroll, in the sense of substituting the United States in as a defendant when Bill Barr subbed in that case, the United States in place of Donald Trump, to the extent it was a press conference that was given by a president. Even when the president defamed somebody in a press conference, the position was at least taken by the current Department of Justice. That is a type of act that a president engages in, executing their constitutional responsibilities, even if it's defamatory. Now, I don't like that outcome. I just want
a different view. I got a different view. I have a different
By the
prediction.
way, I don't want my view to be right.
No. We don't.
Clear.
But wait a minute. We don't do that on this show. We don't do that on this show. We don't do let's shape our opinions and our advice, not our advice giving. Sorry, I forgot what show I was on. We don't give our opinions and our analysis based on what we want the outcome to be. We do it based on our experience and our understanding. I have a slightly different view than you do, not because I don't agree with the precedent. The precedent is the precedent to be applied. I think Amy Berman Jackson, I agree with you on one thing. The Biden administration is definitely going to be, I believe, continuing to assert the executive privilege through the guidance of the Department of Justice. I don't think the Department of Justice would have moved to exert the executive privilege if they hadn't already cleared it through the White House. So I think we're going to go through the motions here a little bit. And on the 24th of March, we're going to have the assertion. But I think as Amy Berman Jackson, and we've seen now her body of law that she's developed over the last 2 years that we've watched, I think she's methodically going to pick and determine whether Trump has put himself out from under the executive privilege and the absolute immunity through certain of his conduct and behavior that, of course, Strzok's and Page's lawyers are going to be arguing, and therefore doesn't enjoy that privilege. It's going to be a tightrope she's going to have to walk. But I think at the end of the day, he's going to get what he needs. I'm talking about Strzok and Page by extension, that they need to prove their case ultimately, whether they get Donald Trump under oath on all of these issues or they do not. The interesting one for me is Christopher Wray, the current sitting FBI director, not Mueller. I guess was Christopher Wray the FBI director when Strzok was there?
Yeah, he was the FBI director.
Right, because Ray hung over for the next, right. Ray's a holdover. That's right. So
and that's exactly why he's being deposed. Yep.
Right. So look, I think at the end of the day, you and I will I think the confidence I have is that I think Strzok's got a very good case as this Page. Whether Amy Berman Jackson finds a way to thread the needle and even with the assertion of executive privilege find a way around it, which I think she may be able to do on certain of these questions. Look, we'll find out. But that's why we do this show, so we can have this dialogue.
But by the way, you and I probably are actually saying the same thing.
Yeah.
Because I think that, the Department of Justice will assert it. However, because in response to this minute order, however, you're right that Donald Trump goes out to this day not in a position right now of being a president, and in connection with his campaigning, and he goes out and he mimics orgasms between Strzok and Lisa Page and mocks him like that. I'm not joking. There's one of the shticks that Donald Trump does here. We'll play that clip right now. Hold on, let me show it to you.
I love you, Peter. I love you too, Lisa. Lisa, I love you. Lisa. Oh, God, I love you, Lisa. And if she doesn't win, Lisa, we've got an insurance policy, Lisa. We'll get that son of a bitch out.
I mean, how disgusting can you be right there? Mimicking it's the behavior and conduct is so sickening and disgusting. But I digress. We will keep our legal AFers updated there. And then let's just talk about right now what is going on in Fulton County. And I'll have you break this down, Popok. But here's the one thing that I do want to say. And one of the things that I think legal AFers will know who have been watching this for a long time. I've been where Fani Willis has done great work, I've pointed it out. But I had also pointed out on prior legal AFs, even her communications with the press, and the types of statements that she had made in the past, and her attending campaign events for people, which resulted in a judge finding at least with one of the individuals who she was seeking to subpoena. One of the fake electors posed a conflict for her office. I was saying, like, that's not what I'm used to seeing. I'm used to seeing kind of complete silence. The motions do the talking, and I had expressed some reservations there. Here, by the way, my overall opinion here is that what this special grand juror, the four persons like the leader of the grand jury. They're selected by the other members of the grand jury. She basically helps organize their deliberations, and she signs the final verdict sheet, or in this case, the final recommendations. It's not going to make a difference in the outcome. Zero. I'm very confident of that. Will it give Trump's lawyers an ability to make another argument now of, this poisoned the jury pool? Look, sure, but he's going to make a bunch of stupid, meritless arguments regardless. Doesn't help to give somebody another extra stupid, pointless argument, but it's not really going to matter. I mean, really, Trump, who posts tweets harassing people and defaming people, he goes on a social media platform every single day. He's going to argue that when this special grand jury four-person mentioned things and didn't mention anyone's name of who's indicted, that poisoned the jury pool, versus him posting all of these things and attacking Fani Willis and saying these kind of racist, hateful, despicable things about all the witnesses and the whole. No, it's not ultimately going to make a difference. But overall here, the part that just is perplexing to me is the whole organization and coordination of special grand jury, which makes recommendations. Then it goes before a grand jury, which actually does the criminal indictments. With this this special grand jury, 26 people, 3 people were alternates, so really 23 people, plus the 3 who makes the criminal recommendation. They prepare their report. They want to release their report. The Georgia statute says their report shall be released, not may. But the judge says, look, just don't say the names of the people. We're not going to release any sections that give the names to protect the due process rights. If you're Fani Willis, though, you have to be like, there's only a certain amount of time before a special grand juror is going to be baited, or that someone from your office is going to be baited. And as we talked about on the last Legal AF, that's what the media would do on its own, because they want to tell the story. Oh, look, the special grand juror spoke out. Oh, is it detrimental that the special grand juror, it's just content for the media, and they're going to try to probe that area. We said that Donald Trump was going to bait them with some of his posts, and and to some extent they did bait her. And this Emily Kors spoke out, and it was strange, the appearance. She's not media trained. I thought her initial statements to the print media was fine and actually pretty careful. I thought the TV appearances were, the only way I could kind of describe it is like it was just a little bit, it was a little bit strange. To go in that setting without media training and be a part of this, this biggest situation ever. I wish that she had close advisors or counsel who could have helped guide her through it. To the extent she did have people, they certainly didn't do their job well. But ultimately, to me, it's not going to have an impact on the outcome. But I don't love the optics of it. But also, like, Fani Willis should have known that that's going to happen. If when she said in January, like in early January, our charging decisions are imminent, The judge was like, this is a report like the January 6th committee report. This should be public, is what the judge said. And then Fani Willis said, keep it private. Charging decisions are imminent. Imminent is a defined word, like about to happen. That's what imminent means. And here we are, February 25th, and the charging decisions haven't been made. And so, of course, someone's going to speak out eventually. But ultimately, my view is not going to impact anything. I still think Fani Willis has done a very good job. This just kind of feels a little bit disorganized, and it's not the types of mistakes that Jack Smith has made or will make. Popok.
I blame McBurney for this. I blame Judge McBurney for this. Fani Willis was caught blindsided by the grand juror, and I'm shocked at McBurney because it seems to be what later reporting came out. I'm going to walk back a little bit of reporting that Karen Friedman-Agnifilo and I did Wednesday when the story broke, because at that moment we couldn't tell exactly if the foreperson was abiding by instructions of McBurney, the judge, or not. And I think we leaned a little too hard, frankly, in our segment on Wednesday about her having violated her oath, when it looks like, based on McBurney's own interviews, and we've got some video, hopefully we'll be able to show, that he's given, and comments made to CNN, Associated Press, the Atlanta Journal-Constitution, that indicate that he's sort of okay with all statements made by any grand juror, and there were 20 plus of them, not just this foreperson who draw the short straw to run the administrative aspects of the jury process. And what he said is, he said, it's not for me to judge whether she violated my rules, which is a very bizarre thing for a judge to say. He spent so much time. We've seen McBurney in 3 or 4 hearings where he even chastised Fani Willis for holding a fundraiser for the opponent of one of the people that she was investigating as part of the fake elector scandal. He had no problem chastising her there. He held a 3-hour hearing. You and I watched it. I reported on it just recently, based on the media attempting to get the entire grand jury report, including its roster of recommendations of who should be indicted and who shouldn't, and what crimes they committed and which ones they didn't. He was methodical about making the lawyers for everyone, including Fani Willis, put on the record their analysis as to whether this was a public report or not a public report. He wanted to protect at the end the due process rights of people that were unnamed. And so he sided ultimately with Fani Willis and let out only 5 pages of the report and no particular comments in it about witnesses or people that were looked at or the final recommendations. Yet he now takes the position that he is fine because he told them the only thing that Georgia law stops or prevents you from doing as a member of the grand jury, the special purpose grand jury, is you cannot disclose your deliberations, and term of art, which the judge went on, because he's now said this into the media, went on to tell them, this is how you know when it's deliberations. If you're talking amongst yourself as jurors and the district attorney's people are not in the room with you, or I'm not in the room with you, and there's no witnesses present, that's your deliberations. Don't talk about that. But he went on to say in the same breath, I'm okay with jurors talking about the final report and its recommendations as long as you don't talk about deliberations. So how did this layperson, the jury's a hard place to be. I've served on a jury. I'm a jury trial lawyer. I've worked with juries. I understand jury science. It's a weird place to be. One morning you wake up and you hope you don't have to serve on a jury. And the next moment you're on a jury being charged with complicated legal, maybe constitutional, maybe presidential, Supreme Court constitutional issues for which you were not properly trained. But I still love our jury system because they ultimately get to the truth because of the way they evaluate facts. So she's not prepared for her role, but Associated Press figured out her name from subpoenas that were issued because they're doing their sleuthing as the media, and they contacted her. And mindful of what Judge McBurney told her, she thought saying things about, you won't be surprised, public, by the defendants that are listed in our recommendations. It's not There's no plot twist. There are multiple defendants with various charges. Her telling people in the media that Donald Trump and the phone call that he made to look for, the 12,000 or so votes, she said that was front and center, obviously including in deliberations, that she gave the reason why they didn't subpoena Donald Trump. That is sort of, for me, moving into the world of what they deliberated about, or at least it is a mixed question of things that were both discussed outside of deliberations and those that were discussed within deliberations. And I'm troubled by, and actually, I'm going to say it, shocked by McBurney, who has run a very tight ship in a very tight courtroom, is now, and they could even talk about the report's final conclusions. Then why, if that's the case, Judge McBurney, why didn't you release to the public through the lawsuit the report if you were okay with individuals, 20 of them or more, going and talking to the media about what they found? So just the deliberation, but the final product you're okay with them talking about? Why isn't the district attorney and the judge responsible for getting out, if that's the case, the actual report and not letting it be through the prism of interpretations of people who, frankly, are not that prepared to do that in the national spotlight? Weird. Fani Willis has been deafeningly silent from her office. The reporting so far has been she was shocked by it. She was surprised by it. She didn't know it was going to happen. But right now, she's got to make a decision. And this is where our co-anchor, Karen Friedman-Ignifilo, comes into the mix. Karen's position, which I tend to agree with, is that she now needs a bigger gap between the regular grand jury and the special grand jury process because of what's just occurred, whether it is right down the line and coloring within the lines of Judge McBurney and his instructions to the grand jury or not, that there now maybe has to be a bigger gap in time. And maybe it limits her ability to use the special grand jury report and just walk it into the regular grand jury seeking their indictment. I want to talk about one other thing before we leave this segment and the podcast. I want to talk about the lawyer that is representing Donald Trump. I think I'm going to do a hot take on this one too. Drew Findling. Ben, you know Drew?
He represents a lot of entertainers and people out there. I think I've spoken to him a few times before.
All right,
so I may not have, but I think I did.
If you're looking for a criminal defense lawyer to the stars in Atlanta, Georgia, Drew's on the list. Very interestingly, though, Drew, because he's represented lots of sort of rappers, Gucci Mane and Cardi B and Offset, Shaq, sports heroes and that kind of thing. And he actually markets himself under the hashtag $1 billion lawyer, thinks very highly of himself. So, he got a gift here with with Judge I'm blaming McBurney, with McBurney not properly coaching or counseling the grand jurors about it. And if he was going to let them just talk out loud, then just issue the report. The report is the best evidence of what they did, not what people's interpretations are. But Drew Findling is interesting because when Donald Trump in 2018 went after and attacked LeBron James and basically attacked his intelligence, talk about racist, attacked his intelligence because LeBron was speaking out about social and civil issues and Black Lives Matter issues and other things like that. When Drew Findling saw that those tweets, he tweeted about his future client. He tweeted as follows: the racist owner of the fraudulent Trump University, criticizing LeBron James, the founder of a school for children, a free school for children, is POTUS being pathetic again. So, it's interesting. It's another example. We talk about Joe Tacopina, who's attacked Donald Trump in the past as well, yet is now taking the money and representing him in a court of law. But if you want to know what Drew Findling really feels about his own client, go back to that tweet that's still up there, actually, has not been removed from Twitter. Maybe we'll put a link to it about what he really feels. But look, Findling, of course, got right on there with his co-counsel and said, this is a circus. the things that she's revealed, a clown show. There we go. This is a circus. This is a clown show because in one of her many now, if you add them up, it's like half a dozen media appearances and interviews. She said things like, oh, I thought it was really cool that I was eating a popsicle that was given to me by the DA because we were celebrating a birthday when I swore in one of the witnesses. Here's my thoughts about meeting Giuliani. Here's my thoughts about, it would have been really cool if I had done it with Donald Trump. And I mean, what is going on? We went from, this very orderly process that we complimented Fani Willis about to things that are like unforced errors at amateur hour. Even if I agree with you, it will ultimately mean nothing in terms of them being able to successfully dismiss or quash the prosecution because of what happened in the special purpose grand jury. Don't think that's happening, but giving them airtime and mileage to talk about these things and lose the narrative. I was also surprised, I don't know if you caught this one, another sort of unforced error for Fani. She retweeted during the Lindsey Graham fight over his testimony. Somebody had created a political cartoon where she was displayed, which portrayed as a fisher person, a fisherwoman, reeling in a giant fish that looked like Lindsey Graham. And she retweeted it. These are the things that, for instance, Letitia James, even though she does press conferences and ran on a campaign about going after Donald Trump, she doesn't make these unforced errors. And we may not like the limited information that we get from Jack Smith because it's really airtight. It's like hermetically sealed. And in the gaps, people are both allowing their anxiety to run away with them and their imagination to run away with them, and also continuously comment on the clock and the pace and the velocity of things. But I would much rather have an airtight, professional run operation than to give the Drew Findlings of the world the ability to call something a clown show, right? What do you think, Ben?
Agree. So Drew Findling, remember, because he represents a lot of entertainers and people like in high profile people in the Atlanta area, he represents a lot. He's on the opposite end of Fani Willis on a lot of issues and some of her recent RICO cases. So his ability to call her out because of his representation of other people that he does as well, that's one of the reasons that I think drew him, no pun intended, to this case. Where I'll disagree with you on, though, on McBurney's going above and beyond actually what the law says. Georgia law is very clear that when the special grand jury is completed and the special grand jury makes a recommendation to release the report, as they did, it shall be released. The word is shall. And we, the people, we, the public, are entitled to answers. It's the reason why it's in the name of the people versus whoever. And we demand and we have transparency, especially when a statute says shall. Now, the underlying deliberations during grand juries are secret, the same way Jack Smith, those grand juries, the criminal grand juries in DC, those are secret grand juries. Everything that's happening is under seal. There may be leaks, or you see people going in and out of courthouses and you could deduce what's taking place, but the actual grand jury is secret. But when the grand jury is complete, indictments are made and criminal discovery takes place, then everything's made public anyway. And because Georgia has this weird special grand jury process, it's not like in all these states they have special grand juries that meet to make recommendations that then could go before a grand jury. Mind you, this whole special grand jury wasn't even needed in the first place. You could have just went to a grand jury and got the indictment there. But the approach from Fani Willis was, let's start with a special grand jury. You know, the statute says at the end of the process, it shall be released to the public if a recommendation's made. I don't see how you can say you're surprised by it being released when the statute actually says shall. And Judge McBurney was doing a solid because McBurney thought it should be released to the public. But he said, look, because Fani Willis, you showed up in court and said charging decisions are imminent. First thing McBurney did was dragged out the process like 3 or 4 weeks so that imminent, all right. And then finally said, okay, I'll just release portions, intro, conclusion, and section 8 of the report, but like, report back to me, let me know what's up here. And I think McBurney, like it or not, was actually following the law regarding the special grand jury process. Now, if McBurney advised people during the special grand jury, hey, you could go out and talk, or the grand jury during the talk. But here's the thing. The clown show, as Drew calls it, the lawyer for now Trump and these other people are saying it. I wouldn't go that far, but there's definitely, it looks like a layer of disorganization. But it is a species of the fact that this special grand jury recommendation is unique and unusual, and how that parallel tracks with the grand jury. You need to coordinate that in a way that, to your point regarding special counsel Jack Smith, you saying hermetically sealed, these paths need to be thought of in a very coordinated manner to reduce the risks here. But I want to give the analysis and the thoughtful analysis that we provide here at LegalAF on these topics where we surgically look at it from all of these different angles. But I ultimately do want to leave with the conclusion: it will not impact Fani Willis's ultimate charging decisions, nor will it actually impact the ultimate outcome, what takes place in Jordan. It absolutely won't at all. But the question, and before I throw it back to you, is,
yeah.
And we'll talk about this on the next LegalAF, and I hope by the next LegalAF there's more news on what's going on in Georgia. Though, is like, all right, like let's get the show on the road and let's get that indictment. The special grand jury completed its work almost 2 months ago now. By the time we do our show in March, let's go.
Yeah. So let me wrap it up with this. And to be clear, my ire with McBurney is that he allowed 23 people to come effectively, because it's not just the 4-person that has the right to speak. It's all of them have the right to speak. And rather, if he was going to do that, then he should have just ruled. I differ with you a little bit on the analysis for a special purpose grand jury and the word shall. I think the judge got it sort of right. But if he was going to go through the whole exercise of having the media brief it and Fani Willis's a colleague brief it and argue in court, and if he was just at the end of the day going to be like, maybe Fani Willis should have thought ahead, as you said, and said, I want to ask you something else. Once this is over, are you going to interpret the deliberation oath requirement for grand jurors to mean that all of them can hit the media? Obviously, she was blindsided and hadn't thought through that. And McBurney, if he had thought about it, if he would have said in that courtroom, let me talk about something that's related. I may not release this is where I have trouble with him, and maybe with Fani for having not raised it. In that courtroom, on that hearing that we reported on, there should have been a discussion then of, if I'm not going to release the report now, you understand, Madam District Attorney, that now that the report is over and under the Georgia law related to the oath of each grand juror to keep deliberations secret, the report itself is not deliberations, nor is things like witness observations. I'm going to let 23 people the day after their discharge be able to talk about these things. Okay? The fact that that wasn't discussed in that courtroom was a mistake. I don't know if it's McBurney for having not raised it or it's the DA for having not anticipated, but it was a mistake that now all the grand jurors, including the 4-person Miss Coors, I don't say took advantage of, but she was not gagged related to this. That's sort of my issue. But I agree with you. Don't think it ultimately has an effect. It may have an effect on, I would have hoped that the imminent meant immediately, but I kind of get a sense of why it's not, because once the report came out and this kind of early hearing happened within just a couple of weeks of it ending, she wasn't ready yet to actually, it's one thing to present a case to the special purpose grand jury. It's another thing to then figure out how you're going to take that report and or the witness transcripts and or live testimony into a regular grand jury and get the indictments based on the recommendations, some of which she may not agree with. She may not think the case is as strong as the grand jury did on some of the people listed on the roster, and she wants to present her case. So it's been taking her longer even though she felt she had to use that word imminent. Imminent for her and imminent for us are two different things. She's still picking through, obviously, how she's going to present her case to a regular grand jury. Now she's got a new curveball that's thrown at her, which is, does this impact what I need to do, how I need to do it, if I'm able to use the special purpose grand jury to take away the argument by Finlings of the world that it's somehow corrupted? Or do I just double down on it? Because even McBurney has said everything was done appropriately by the special purpose grand jury and the DA. Do I just take that under my arm and with my witnesses make the presentation? That's taking longer, but you're right. It's allowed these things to happen. But I think it started with the hearing we reported on 3 weeks ago. The judge should have said, you get, even though I'm giving you the report not being disclosed, you get that the jurors can talk about the report, right? That should have been a discussion, and it wasn't. And that's my problem.
Well, we will definitely follow up more here on Legal AF. I hope you can kind of see the types of communications that that Popok and I have behind the scenes here on the show, and the way we think about these issues from each and every angle as we present them to you. Things are going to start heating up. They're already heating up. So there's a lot of breaking news that we will bring you with our hot takes. And of course, on the Wednesday edition of Legal AF and the weekend edition with myself and Michael Popok. Do me a favor, if you can, make sure you subscribe to the MeidasTouch YouTube channel. We are on our way to 1 million subscribers, thanks to your incredible support. In March, we're calling it the March to 1 million subscribers. Also, make sure to check out our audio by subscribing to the Legal AF audio. Just search wherever you get your podcast, Legal AF. It goes a long way to help this podcast if you subscribe to the Legal AF audio podcast and not just the YouTube channel. So for all of our YouTube watchers, please, at the end of the show, go and search Legal AF on your audio podcast service, wherever you listen to it, and subscribe there and leave a 5-star review. Check us out at patreon.com/MeidasTouch, patreon.com/MeidasTouch. You'll love the exclusive content we have there, but most importantly, it helps grow this platform. And of course, you can check out Popok's hot takes as well as my hot takes on our YouTube channel. Thank you, everybody, for watching this episode of Legal AF. We will see you same time, same place next week with a special shout out to the Meidas Mighty.